So, Mr. Dobosh, last week, Ukrainian state-owned bank filed a billion-dollar lawsuit, and some people already say that it's different from the previous investment disputes between Ukraine and Russia. So, can you explain us what is so different in this case?
It is indeed different because in all the other cases, the tribunal, the arbitral tribunal, decided to split the proceedings into two stages. The first stage will be deciding whether the tribunal has the jurisdiction and competence to hear the case on the merits, and the second part will be the very hearing the case on the merits.
And obviously, Russia is disputing jurisdiction of the tribunals, right?
Russia is disputing the jurisdiction of the tribunal, as it clearly stated that the bilateral agreement the disputes are based on is not the proper basis for raising any claims and composing the arbitral tribunal.
And in fact, right now, there are cases which are being heard by the Permanent Court of Arbitration in The Hague on other investment disputes on the point of jurisdiction. Is that correct?
Yes, they are heard on the point of jurisdiction. In 4 cases, the claimants are waiting for the decision of the tribunal on the preliminary point of the existence or the non-existence of the jurisdiction. And in Oschadbank case, the situation is slightly different because the court decided not to split the procedure into 2 parts, but to hear the issues relating to the jurisdictional matters together with the issues on the merits.
But Mr. Dobosh, can you explain from the legal perspective, how does Russia justify its position? Russia annexed Crimean Peninsula more than 2 years ago. It claims that Crimea is part of Russia's territory. So why Russia refuses to participate in these investment disputes right now?
Because if it participates, there is a serious risk for Russian Federation to lose, and by participating in full, it recognizes the jurisdiction, and if the Russian Federation loses the proceedings, it shall be bound to pay very significant compensation. So what Russian Federation does, saying that there is no basis to sue under the bilateral investment treaty, and Russian Federation does not submit with the court the defense, does not take participation in any conferences, does not answer the question, did not appoint the arbitrators, and so forth. It is denying everything.
But if Russia follows this strategy of denying, isn't it the case that the court can still hear this case without Russia's presence or without Russia's participation, and the court even can find in favor of the Ukrainian side?
Sure, that is absolutely true, because the Russia is fully informed about all the procedural steps that are being taken within the proceedings, and it is given a full range of opportunity to present its case.
So what happens next? Let's imagine that the court does find in favor of Ukrainian side. Russia, obviously, which does not participate in the court hearings, which does not recognize the jurisdiction, will obviously not recognize the court's decision.
Well, first of all, I believe that a Russian Federation will challenge the arbitral award at the seat of the arbitration. That will be a challenge, the appeal in Hague. And furthermore, I believe it will not be possible for the claimants that won the cases to recognize and enforce those arbitral awards within the territory of the Russian Federation, taking into account the latest law of the Russian Federation enabling and authorizing the Constitutional Court of the Russian Federation to ban any recognition and enforcement of foreign decisions, provided they are contrary to the provisions of the Constitution. But as far as the provisions of the Constitution are extremely broad, there is some space for manipulation. So what will happen is that the winning parties will try to seek the assets in other third jurisdiction, to trace those assets and trying to enforce against those assets.
Mr. Dobosh, can we discuss the prospects of the Oschadbank case? So right now, the lawsuit has been filed, and it is our understanding that both matters on jurisdiction and the case on the merit will be heard by the court simultaneously.
Yes, that's true. In one single hearing, which, by the way, is scheduled for March 2017. So next year we will probably have the first arbitral award. In addition to that, the Oschadbank filed a motion with the arbitral tribunal in Hague asking for the expedited proceedings, which are slightly simplified and faster, in case if a Russian Federation continues not participating in case at all.
Do you think that Russia will follow its previous practice and ignore, or let's say boycott, this court hearing as well?
I believe so, because if there is one single strategy, it has to follow it till the end.
In case the arbitration finds in favor of the Ukrainian side, how easy will it be for the Ukraine to enforce this decision against Russia in the third countries, in the third jurisdictions?
It will be a tough exercise for them, but they will obviously use the provisions of the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. And it will be possible to recognize and enforce those final arbitral awards in third jurisdictions. However, we do understand that it will cause significant expenses for the claimants to trace, to seek the assets. However, they are obviously perfectly aware of what is at stake, so it's worth it.
So, in your professional opinion, is this lawsuit more of a legal nature or more of a political nature to pressure Russia again?
I believe they are both, because as the Oschadbank case is probably to be the first case which reached the final arbitral award, I believe that as far as the investment arbitration is an area where the court precedent is valued, I believe that the decision reached in Oschadbank case may cause snow avalanche, and all the other aggrieved investors may follow that way, and Oschadbank may potentially be the case which will be a guideline for them.
Mr. Dobosh, can we briefly discuss the developments in other cases? There is a number of cases of Ukrainian oligarch Mr. Kolomoisky and his businesses against Russian Federation, again for the losses which were suffered by his business empire in Crimea. And right now, as we already discussed, the hearings already started in The Hague on the jurisdiction. What's next in these cases?
So in case of Ukernafta and Stabil, those two claimants are waiting for the decision on the jurisdiction. They have already filed the post-hearing submissions. In case of Airport Belbek, which is based on the appropriation of the airport terminal, they are also waiting for the decision on the jurisdiction, as well as in the case of Private Bank. And in two other cases of Mr. Kolomoisky affiliated companies which lost their real estate assets, the hearing on the jurisdiction have not even been scheduled yet.
Understood.
And in case of Naftogaz, they're exhausting the 6 months rule in order to file an official claim against the Russian Federation at the arbitration.
You mentioned Naftogaz. Is this another case in the pipeline?
Yeah, it is a case, because what Naftogaz alleges is that it lost 15 deposits of oil and gas situated both on the land and on the continental shelf, around 1,200 kilometers of pipelines, around 43 oil and gas stations, and 4 floating rigs, the so-called boycott towers. This will be another serious claim, I believe, even with the claim amount twice as Oschadbank.